Hey besties, welcome back to my channel. Remember when I broke down the Van Zandt lawsuit and explained that Blake Lively and Ryan Reynolds used it as a mechanism to obtain documents from Stephanie Jones? And remember how I said from the very beginning that this lawsuit looked like a sham because it didn't contain any factual allegations tied to the film, to Justin Baldoni, or to any alleged misconduct? Instead, the lawsuit was entirely about marketing, reputation, and an employee they already had a contract with, someone they believed could damage their image. And I said at the time, this doesn't make sense as a real lawsuit. What made it even more suspicious was how they used Van Zandt to avoid service and notification requirements, and how Blake Lively's team tried to act like that was totally normal, like they were just using a harmless discovery tool, and all the outrage over Van Zandt was fake or exaggerated. Well, now we have confirmation. Lively's attorneys have officially filed their R56.1 Statement of Facts alongside their motion for summary judgment, and in that filing, they do not dispute the very facts they spent months denying publicly. They admit that the Van Zandt lawsuit was filed on October 1st, and they admit it was used specifically because New York law allows pre-issue discovery without notifying interested parties. That's undisputed. They also admit the lawsuit was filed even though the complaint did not reference the film or Jones works at all. Undisputed. They further admit that the filing of the lawsuit and the issuance of the subpoena created a legal mechanism that allowed Lively, through Van Zandt, to claim she legitimately obtained documents found on an employee's phone, documents that Stephanie Jones otherwise had no legal right to turn over without a court order. Undisputed. Now watch the sleight of hand. When the statement of facts explicitly references documents found on Jen Abel's phone, Lively's team ignores that language entirely and reframes it as merely categories of documents requested. They then claim ignorance about whether Jones could legally hand them over without compulsory process. But here's the problem. If Jones could legally hand them over anyway, why file the lawsuit at all? There is no innocent explanation for that. Lively's team also does not dispute that the New York Times published an article containing the contents of Jen Abel's phone. Instead, they attempt to argue, without evidence, that the article didn't rely on documents obtained through Van Zandt. That argument collapses on its face. They admit they obtained the phone contents. They admit they communicated with the New York Times. And the article contains direct text messages from that phone. So what do they do next? They try to distance themselves by claiming the CRD complaint alleged similar facts, essentially saying, don't focus on how we got the information, just look at the bigger picture. That's not how the law works. The bottom line is this. In court filings, Blake Lively has now admitted exactly what many of us said all along. Van Zandt was used to obtain an employee's phone, content that Jones did not have the right to search, and it was done in New York specifically to avoid notifying parties in California. Had this subpoena been issued in California, Jen Abel, Justin Baldoni, and Wayfarer would all have been legally entitled to notice. For months, Blake Lively and Ryan Reynolds, through their agents and attorneys, told the public this wasn't true. But in court, under penalty of perjury, they had to admit it. That's gaslighting, plain and simple. Now let's talk about Jamie Heath. You'll remember that Heath claimed he showed the disputed trailer or birth-themed video not only to Blake Lively, but to another person who was present at the time. That person was Angie Giannetti. Giannetti testified in her deposition that the image Heath showed her matched what's described in the lawsuit. Yet Lively's response disputes that to the extent it suggests the same material was shown to both women, claiming Giannetti does not know if the video was the same. Ask yourself, what are the odds that Jamie Heath is on set showing two executives two completely different videos under the same circumstances? You now have deposition testimony from a Sony executive contradicting Blake's characterization, yet she continues to insist this was pornographic material. It wasn't, and doubling down doesn't make it true. Finally, let's talk about the so-called 17-point agreement, the document Blake claims constitutes her protected activity. She's argued that this letter put Wayfarer on notice of alleged sexual harassment and triggered preservation obligations. But here's the undisputed fact. The email does not mention sexual harassment or discrimination at all. Lively's team now argues that she wasn't required to use specific buzzwords like sexual harassment or discrimination to engage in protected activity. But those aren't buzzwords. Those are legal terms. Calling them buzzwords is PR spin, not law. When you report protected activity, you identify the protected conduct. You don't vaguely gesture and hope everyone reads your mind. So, once again, we see the pattern. Publicly, deny, deflect, outrage. In court, admit the facts, then reframe them. That's not accountability. That's damage control. Have you ever been sexually harassed? I have. Have you ever been sexually assaulted? I have. So imagine telling someone that this happened to you, and their response is essentially, "Why are you using those buzzwords?" That's what stopped me in my tracks here. The term buzzwords appears in Blake Lively's filings, and I'm honestly appalled that her attorneys allowed that language to be used. Sexual harassment is not a buzzword. Discrimination is not a buzzword. These aren't trendy phrases or marketing jargon. They describe real, serious experiences that carry legal meaning and real-world consequences. Referring to them this way is deeply offensive and shows just how unseriously this case is being treated by her own legal team. What's also undisputed is that Blake never contacted Human Resources. She never filed a sexual harassment complaint with Sony or Wayfair's HR departments at any point. She admits this outright. Yet she claims that she engaged in protected activity by bringing forward sexual harassment claims. That raises an obvious question. If you didn't go to HR, didn't file a complaint, and didn't alert the employer through the formal process, what exactly are you claiming as protected activity? Her response is that the concept of a formal sexual harassment complaint is vague. It isn't. In a workplace setting, it is very clear. You report it to Human Resources. That's the process. That's how the system works. Then there's the trailer incident. She doesn't dispute that Jamie Heath entered her trailer with her permission. What she disputes is that he didn't remain turned away the entire time and that he glanced in her direction. But that's exactly what Jamie has said consistently from the beginning. When forced to address the facts directly, she can't actually dispute them. We've seen this pattern before, most notably with the birth scene incident that both she and Angie witnessed. When confronted with documented evidence, the story doesn't collapse dramatically. Instead, it quietly shifts. And that's what's troubling here. It feels like Blake Lively operates in what I can only describe as alternative facts. We hear a version of events presented publicly, but when those claims are examined under oath, they start to unravel. Here's a clear example. In August of 2024, Justin Baldoni made repeated positive comments about Blake in the press. This is undisputed. When asked whether he would direct the film's sequel, he told Entertainment Tonight, "I think there are better people for that one. I think Blake Lively is ready to direct. That's what I think." Her legal response disputes that this was a positive comment because the public later connected it to rumors that Blake and Ryan wanted control over scripts and edits. Think about that. She's arguing that praising her ability to direct somehow isn't positive because of speculation that came afterward. That's not how facts work. We see the same issue with the so-called Shasti Flaw video from 2016 that resurfaced during this controversy. The New York Times framed that clip as the spark that ignited the backlash against Blake and suggested it was part of a coordinated smear campaign. They implied that because the interviewer had once supported Johnny Depp, she must be connected to Melissa Nathan, and therefore the video must have been planted. But here's the problem. Blake now admits she has no evidence of that. It's undisputed that there is no proof the defendants had any contact with the reporter or that the video was orchestrated. That completely undermines one of the central pillars of the alleged smear campaign. Once you start pulling at these threads, the entire narrative begins to unravel. One claim collapses, then another, then another. That's how credibility is lost. This is exactly why Shasti has always said she doesn't believe Blake, because Blake accused her of being part of a smear campaign that never existed. And when you look at the events leading up to the film's editing and premiere, what's striking is how much Blake doesn't dispute. She doesn't dispute Ryan Reynolds planting stories. She doesn't dispute the testimony about the WME phone call Ryan made. She doesn't dispute the behind-the-scenes pressure. In fact, something previously redacted by Wayfair was later unsealed, stating that Lively has been brilliantly choreographing this for a while. That single line says more than pages of argument ever could. When WME described Blake as choreographing this, what they were really saying is that she was orchestrating everything from the start, specifically to keep Justin Baldoni out of the premiere and ultimately take control of the film. That language matters because that text had originally been redacted. Blake herself later included it in her response. So WME's position was clear. This wasn't reactive. This wasn't damage control. This was a plan from day one to take over the project. And when Blake's team tries to pivot and say, "Oh no, it was actually maximum effort that did the marketing," they immediately contradict themselves by then claiming, "Well, actually, this was the marketing Wayfair approved. It was your marketing." You can't have it both ways. Either maximum effort ran the campaign, or it was Wayfair approved marketing. The story keeps shifting. Once you start digging through the filings, the contradictions pile up. There's a reason why in their motion for summary judgment, they don't even attempt to argue half of these issues. They can't. They're claiming $160 million in damages, but they can't defend that number under the contract. And that's the core problem. If Blake wants the contract enforced, then she has to accept the contract's limitations on damages. You don't get to selectively apply the parts of the agreement that benefit you and ignore the rest. So on one hand, her team is insisting that California law and the contract must control. On the other hand, they're seeking damages that the contract simply does not allow. That's why they can't properly argue damages. They know the numbers don't work. And because she can't tie the defendants to planting stories, can't tie them to the Shasti video, and has already admitted key facts in the Van Zandt situation, we're left with her actual explanation for the so-called smear campaign. And this is where it completely falls apart. Her argument is that Wayfair amplified videos and content where people were supportive of Justin Baldoni. That's it. That's the smear campaign. In her own examples, she's not saying they planted negative stories about her. She's saying they boosted positive stories about Justin and tried to suppress negative stories that her own team was planting about him. Her claim is that by elevating positive content about Justin, the algorithm somehow turned against her and pushed negative content about Blake. That is not how algorithms work. Justin Baldoni and Blake Lively are two entirely separate search terms. Justin receiving positive coverage does not cause negative videos about Blake to magically trend. Blake has a much larger public profile and audience, so of course she experienced more backlash when controversy hit. That's not manipulation, that's scale. There was no smear campaign. A team promoting positive coverage of their client while attempting to shut down negative narratives being pushed against him is not a smear campaign. It's standard crisis PR. And that's why they can't win this argument. They've effectively admitted it themselves in court filings. So, are you surprised by any of this? Let me know what you think in the comments below. If you found this helpful, give the video a thumbs up, subscribe to the channel if you haven't already, and click the bell so you never miss an update. Thanks so much for watching. Bye!